Good morning, everyone. I welcome you all to this one-day conference on Insolvency and Bankruptcy Code. We at Ahmedabad branch are delighted to have this conference. The main features are we are having the best of the speakers, almost 18 plus speakers in a day, and also we are having the best of the innovative subjects that we have tried to catch up on. I welcome you all. Now I request Purushottam Khandelwal sir, Central Council member, Durgesh Kabraji, the Vice Chairman of Insolvency Committee Board, the Central Council, to escort Samir Kakkarji, the Honorable Judge of NCLT Ahmedabad, and also Suman Batraji, Advocate Delhi, to escort them to the dais. A big round of applause for them. Now I request all the members to rise up for the ICAI motto. Before starting this conference, I request all the dignitaries on the dais to join us for the lighting of the lamp. Also the managing committee members, Vikas Bhai, the regional council member, Samir Bhai Chaudhary, to join us for the lighting of the lamp. Dinal Bhai. Now I request Chairman of Ahmedabad branch of WRC of ICAI to address the gathering.
Respected Chief Guest, Honorable Judge of NCLT, Sri Samir Kakkarji. Keynote Speaker, Advocate Suman Batraji. Central Council Member and Vice Chairman of this Committee, Insolvency and Valuation Standard Board of ICAI, CA Durgesh Bhai Kabraji. Central Council Member, CA Purushottam Khandelwal ji. Secretary of the branch, CA Sunis Shah. Regional Council Member, CA Vikas Bhai Jain. Immediate past Chairman, CA Dr. Anjali Choksi. Managing Committee Member, CA Samir Chaudhary. Past Chairman of the branch, CA Raju Bhai Shah. Managing Committee Member, just now joined, CA Abhinav Malavia. Advocate and Chartered Accountant, Dinal Bhai Shah, and all dear participants from Ahmedabad and who has traveled from outside Ahmedabad also. Very good morning to all of you. I welcome all of you to this conference, one-day conference on the Insolvency and Bankruptcy organized by Insolvency and Bankruptcy Board, ICAI, and hosted by Ahmedabad branch. I also welcome all the expert panelists and faculties of the conference who have traveled from various cities, maybe Hyderabad, Kochi, New Delhi, Mumbai, Chennai, Coimbatore, and various other places, like topics like interplay of IBC with income tax, mediation in insolvency, funding resolution, and resolution of personal guarantors, and other topics. IBC is a landmark reform that consolidates all the pre-existing laws dealing with insolvencies in India. The IBC has had a significant impact on the Indian economy since its enactment. The IBC has provided more efficient and effective system for resolving the insolvency and bankruptcy cases, leading to faster recovery of dues for creditors and a more transparent process for resolving insolvency. I believe that number of insolvency professionals are very less in India, and more this type of conference should be held for the awareness of this profession. Under IBC, the business can either get a chance, if still viable, to start afresh with the new owners, or its assets can be liquidated or sold off in a timely manner and with a maximum value. At the end, I wish a great learning from this conference to all of you, and at the end of the day, the great networking also. My best wishes to all of you. Thank you.
Thank you, Sunil sir. Now I request Chairman of Ahmedabad branch, Sunil Sanghvi sir, and Durgesh Kabraji, the Central Council member, and Chairman of Insolvency Committee of ICAI, to felicitate Samir Kakkarji with a bouquet and a memento. A big round of applause for him. Now it's my privilege, and I request Purushottam Khandelwal sir, Central Council member, to felicitate Sumant Batraji, Advocate Sumant Batraji from Delhi, with a bouquet and a memento. Now I request Regional Council Member Vikas Jain to be on the dais, and also past Chairperson of Ahmedabad branch, Anjali Choksi, to felicitate Durgesh Kabraji, Central Council Member, and the Chairman of the committee, with the bouquet and a memento. Now I request the Managing Committee Member Abhinav Malavya and Managing Committee Member Samir Chaudhary to be on the dais and felicitate our own Central Council Member Purushottam Khandelwalji with a bouquet and a memento. A big round of applause. Now I request Purushottam Khandelwal sir, Central Council Member, to address the gathering.
Good morning. Chief guest for the today's function, CA Justice Samir Kakkarji. Keynote speaker, Sumant Batraji. My colleague in the council and the Vice Chairman of this Valuation and Insolvency Standard Board, Durgesh Bhai Kabra. Chairman of this Ahmedabad branch, Sunil Bhai Sanghvi. Secretary of the Ahmedabad branch, Sunit Shah. Of the dais, Regional Council Member Vikas Bhai Jain, past Chairperson Dr. Anjali Choksi, Managing Committee Member Abhinav Malviya, Samir Chaudhary ji, past Central Council members Dinal Bhai Shah, Raju Bhai, and respected members. It gives me immense pleasure to be amongst you. I congratulate and compliment to Ahmedabad branch for hosting a one-day conference organized by the Institute of Insolvency and Valuation Standard Board of ICAI. Last year, we have organized a two-day conference, Resolve at Singapore. After success of this conference, this year we are also organizing this conference in New Delhi. Yesterday, Agyan Mishra ji told me that we plan to host a very good conference at Delhi. So I humble request all the members, those who are willing to attend this conference, please attend the conference at New Delhi. Yesterday, the council has approved the policy of COE, Center of Excellence. Currently, we are having a two Center of Excellence at Hyderabad and Jaipur. Apart from these two COE, yesterday ICAI approved 8 more COE to provide a best facility to members, where the International Research Department, Incubation Center, High-Tech IT Lab, Digital Library, campus-based learning, classroom training, dedicated team of officers to monitor all the proposed activities, dean, directors, and wardens. So I say plan for next generation to come in the CA course. Not our main intention to do the audit and income tax work. The purpose for which the institute has been established to carry out the research work, to provide a best facility to members, those who want to research. They will come to the COE and we will provide the best facility to the members. Yesterday, we also meet the chairman of NAFRA, Ajay Bhushan Pandey ji. He addressed to the council where he categorically told that how to monitor the attestation function done by the chartered accountants. Audit is a serious business. He quoted one example yesterday, कि one husband and wife doing a practice. Husband and signs the financial statement and not follow the accounting standards to be followed. The CA was honest. The NAFRA called him for the hearing. He accepted that I am not aware much of the accounting standard and auditing standard, but now I decided that for the 1 year I will not carry out any attestation function, but the whole year I will invest in the understanding the accounting standard and auditing standard. So those who are in the attestation function, my humble request to take seriously as an audit. ICAI has also come out with the peer review last date. 5 and more partners, the last date of peer review is 30th June. And thereafter you cannot do the attestation function. And 4 or more partner, the last date is 31st December. So I will not take much of the time because the keynote speaker is here, my Central Council colleague is here, Judge Sir is here. So once again, I congratulate and compliment to Ahmedabad branch for organizing such a wonderful program. Thank you, sir.
Now I request Chairman of Insolvency Committee and also the Central Council member Durgesh Kabra ji to address the gathering.
Good morning, one and all. It's indeed a pleasure to be always at Ahmedabad. The warmth which is being received whenever we visit Ahmedabad is fantastic. And not only when we visit, but warmth which is being extended to the branch by all the participants in large number. This is fantastic. And for all that, the credit goes to the leadership of Ahmedabad branch, duly guided by the Central Council member and immediate past president of the institute, who is from the Ahmedabad branch. Friends, as far as the various initiatives at the institute are concerned, it has been told by my colleague Purushottam Khandelwal, a person who is doing fantastically well at the institute into the various activities, and you all know that what kind of role he played when this particular building was constructed at Ahmedabad, where the branch got shifted. Coming back to the Insolvency and Valuation Standard Board, now it's a board, and which is a combination of Valuation Standard Board as well as the Insolvency and Bankruptcy Committee, when these two were there. And when there is only one regulator for both the kind of activities, the institute leadership thought fit that instead of having two different committees at the Central Council, I think it is right to have one where every suggestions, every activity for the benefit of the members who are into these line of practices and making their career into these can be taken care by one single entity as a committee at the institute level. Friends, as is told by Purushottam Khandelwal with respect to the Resolve 24, which we are going to have it on 12th and 13th of July. The time is less. The announcement for saving the date has already been done, and soon, in next 2 to 3 days, we'll be giving the complete details with respect to the registration or so. And my humble request to all of you would be that please attend in large number, and this event is going to be at one of the best location in Delhi at Bharat Mandapam. I think Bharat Mandapam, when you visit itself, is a fantastic venue where G20 can happen. Then why not this Result 24? And with the support of all of you, when you attend this fantastic event, which is the second edition of the first event, which we held at Singapore in 23, which was attended by more than 150 chartered accountants from across the India and another 150 from Singapore. So here we are thinking of having more numbers from India only, and expectation is of around 500 or so. Some early bird incentives are being given to the members, and thereafter the charges will be more. Since it is an international conference, Resolve 24 is an international conference, it has own standard in having and building the capacity of our members. Friends, we do have various groups at the Insolvency and Valuation Standard Board, where we are suggesting where various things under the review of rules of IBBI or under the IBC, which is being proposed, or any concept paper which is being proposed, we give our comments and we are having the groups for the same. Any of you who is interested in being the part of these technical group, feel free to write to us at ivsb@icai.in, or you can write durgeshkabra@icai.in, where we'll take your services to improvise, to suggest to IBVI, and do the various activity for the benefit of the members at large. We do have, as you all know, that valuation standards are being published by the institute. We have 8 valuation standards. The ICAI is the only body in India to have the valuation standards. though the valuation work is done by the registered valuer and the various standards are being used. Maybe it is international valuation standards, maybe some other valuation criteria. So far, India or IBBI has not given recognition to any particular set of standards. But we are in dialogue with the Ministry of Corporate Affairs as well as IBBI that there should be a set of valuation standards recognized which is being used by each valuation registered valuer in valuing the financial asset class as well as the other asset class. And let me tell you, friends, we are having it today. We have been recognized, our RVO has been recognized for the other asset class too. Till yesterday, I would say that we were having the financial asset class category with us where we were training and we were taking the exam and certifying, and the valuers were becoming the members of ICAI RVO. But now, in other two class also, fixed assets and so the other, there also we will be having the exam system, exams, and you can be the members into it after you have a qualification which is required for the same. Friends, beside all these things, regular activities like the conferences, like the residential refresher course, like the one-day seminar, workshop are being done. We are also having the certificate course for valuation as well as for the insolvency and bankruptcy, which is being done in virtual as well as physical mode, which normally help all the members to understand what are the various nuances in the insolvency and valuation. And friends, let me tell you, this is the area where you can have wonderful opportunities, provided that everything has to be taken seriously. As very rightly said by Purushottam Khandelwal, that very recently when NAFRA chairman has visited day before yesterday at the ICAI, he said that they are going to understand first and going to take actions later on. We need to understand, we being the professional brothers and sisters, who has to have the best knowledge of the accounting and auditing standards. And the same is required to be used in resolution, in evaluation, and in assurance services. May it be transaction audit, may it be forensic audit, may it be some other kind of assurance services. But unless and until we do not do this with a serious need, I think it is going to create problems for us. So my humble request to all of you would be, take any profession for you, but the services which are required to be rendered by us has to be taken very seriously. I think these are the things which we are taking care of. One more thing which I just want to tell you, that 3 regular publications are there from the IVSB. One is monthly knowledge corner, which is having the case digest, which is very helpful for all of you, that what are the new cases by the Supreme Court and High Court, which updates your knowledge as far as the valuation and insolvency is concerned. Then we have a monthly quiz on IBC and valuation, where one can participate. And then there is Valuation Age, which is a quarterly newsletter with respect to only and only valuation subjects. So these 3 regular publications are there, which helps all the IPs and registered valuers for building their capacity in terms of having or increasing the knowledge. And I'm sure, friends, if you go through all this, I think you will have the updated knowledge. Friends, feel free to write to us, because very soon the rules are going to change for the IBC, and we are going to suggest to the Insolvency and Bankruptcy Board. So feel free to write to us when it is being uploaded over there. Whatever your suggestions, we will aid this into our presentations to the IBBI. With this, friends, thank you very much for being here in the large number, and thanks to Samir Kakkarji, who has graciously accepted the invitations of being the chief guest, and Suman Batraji for having present as here and giving the keynote address. Thanks to one and all. Thank you.
Thank you, Durgesh, for such a wonderful deliberation to the members on insolvency and bankruptcy. Next, I just briefly introduce Suman Batraji, and then we'll have his address. Suman Batraji is an insolvency lawyer of global eminence, an international fellow of the American College of Bankruptcy, distinguished fellow of the Indian Institute of Corporate Affairs, and visiting professor of National Law University. He has been ranked as amongst the top 30 restructuring lawyers in the world. He is the founder of the Insolvency Law Academy, the country's first institute of excellence in his insolvency. He is the founder of Indian Cinema Heritage Foundation, a public trust to the document the rich history and heritage of Indian cinema. Together with Google Art and Culture, Cinemazi has launched a digital storytelling project of the Indian cinema history, www.cinemazi.com. He has published rare books like Batraji is the founder of Kumon Literary Festival, the country's premium traveling literary festival. His coffee table book, The Indians, was the bestsellers and reviewed rave views. And also he has released, I have also read the book, he has released the book, The Tale of Love of Anarkali, which has been the historic bestseller as of now. With this brief introduction, I would say it's a long introduction he is having, but with this brief introduction, I would say I will request him, the most versatile lawyer, I would say, to address the gathering. Please, sir. A big round of applause for him.
Thank you so much, Sunit, for a very generous and kind introduction. A very good morning to all of you. Shri Sadiq Makharji, the Honorable Member of the National Company Law Tribunal, the and members of the Central Council of the ICAI and the Ahmedabad chapter, my friend Dhinal Bhai Shah, very many colleagues that I can spot in the audience, and dear friends. First of all, thank you so much for having me here. It's always a pleasure to be at any of the events of ICAI. I was at Singapore for the Resolve event in Singapore, which was a great success given that it was done beyond the borders of India. It was very, very largely attended, and the program was of great content, and so was the quality of discussion. And I'm sure the one that is being promised later this year is also going to be as successful, if not more. We all know that Insolvency and Bankruptcy Code is now a little over 7 years old. 7 years is a very short time in the lifespan of any law, and especially in economic law, and that too when it happens to be a law that is designed for a free market economy and is introduced in an economy which is so young as a free market economy. We all know that the Indian economy opened for globalization only in the mid-90s. And given that, it was a great leap of faith, as I would say. But what has been achieved in the last 7 years is phenomenal, not just remarkable. We may have had some disappointments, we continue to debate that, but that's probably an outcome of any churn that happens when you throw into the water a law as massive and weighty as an Insolvency and Bankruptcy Code. Yet, what it has achieved in terms of settling the jurisprudence, or how the jurisprudentially it has grown, is just unprecedented. Nowhere else in the world have we seen a law evolve so sharply, so swiftly. Even in countries like US and UK, for that matter, even Australia and Singapore, where the law is seen as a very mature law, It has taken them over 30 years to be where they are today. And for us, we are already competing with some of the best in less than 7 years, which is no mean achievement, I must say. And obviously, there is always a scope for improvement. Many countries tend to review their laws in about 4 to 5 years. US tends to look at their laws, in fact, almost 30, 40 years, because they believe that the market forces work to correct the weaknesses in the law. That's the dynamic of an insolvency law. And so has been the case in India as well. But at the same point of time, the government has been very proactive. IBBI has been very, very proactive. The market itself has been so proactive in terms of how we have matured as market players. The way we have handled some of the most complex insolvencies is not something which can be undermined in their importance. It needs very, very sophisticated players to deal with the complexities and the scale of the insolvencies that we saw in the first 30, 40 odd cases that were pushed into insolvency. And at a time when IBC had just stepped out of the womb of the parliament, it had not even opened its eyes. You had RBI pushing some of the most complex, 25% of the total NPLs in the books of the accounts being sort of suddenly thrown into the insolvency system. That was the level of confidence in the, not just the law, but also the political will that stood behind it to make sure that the law would get implemented. And the results are there for us to see in terms of the numbers that we have as outcomes, whether it is the recoveries that have been made or also the how the NPLs have gone down, but more importantly, how it has brought about the behavioral change. But I see something more significant as an outcome coming out of that, that is the policy responses. Because we have always seen in the past that India has been always at the forefront of making best of the legislations, but it's the implementation where we have failed invariably in the past. But this is something which has in fact outdone almost all track records, if I may say, of how laws should be implemented on ground. And it has been done breathlessly, tirelessly, relentlessly, without in a moment of putting the guards down, if I may say. Yet, there may be areas where you as market players might be feeling disappointed. We as lawyers feel disappointed when there are judgments that may not really be consistent or when there are disruptions caused by the judgments. But all that is part of the growth of any law. A law would tend to stabilize after a couple of decades when you've almost addressed every single gray area in the law. But insolvency law also doesn't allow that luxury because the fact remains that it's a very dynamic law. It often tends to move ahead of the policymakers. It tends to move ahead of the market also, given its interrelation and interface with the economy. But I'm sure all those issues that you would talk about during the day will get addressed in time. I don't want to talk about the same issues. Those are very well known, written about, talked about, discussed, deliberated, and all are part of the discussion papers of the government as well. I want to talk to you about 5, 6 issues which I believe in the next 4 to 5 years would catch the attention of the policymakers. Some in the short term, some in the mid-term. And one of these 4 or 5 topics is the issue of climate change. We have spoken a lot about ESG. We have spoken about the climate change in the context of how it affects the lives of people, how it affects the humanity, how it might also even affect the economies for that matter. But in the last about 6 months to 1 year, the attention of the policy experts has actually dropped down and, if I may say, narrowed down to the issue of how the climate change might impact the insolvency policies. And given the importance, given the issues that have been identified over the last 6-8 months, the World Bank has constituted a task force of 12 people from around the world to look into this issue, and I have the privilege of being on that task force, and we met once in Washington earlier this year and spent nearly 2 days discussing the issues that were identified by an academic who was asked to do a paper on this to sort of bring out the problems. And then, of course, we sat down to see if there are more problems and how these problems could really be addressed. And then, when I came back, we decided that we should do a deep diving into that from the Indian point of view, and we've come out with a paper as well. It's still a problem paper, but we presented it at a round table with the Ministry of Corporate Affairs, and IBBI was also present, and I think there was a clear unanimity amongst those who were present that this is an issue which needs to be taken up on priority. And I'll just give you 2 illustrations for that matter, not go too much in detail, but it show the importance of the issue. If you see the trend, the claims from climate change or the risks of the climate change today have increased substantially as in litigation. Climate change has 2 kinds of risks. One is the physical risk of the climate change, and the other is the transitional risk. The physical risk is, of course, when you have wildfires, or if you have thunderstorms, or you have all those kind of floodings and things like that, which causes damage to the property, the assets, the businesses, to the jobs. Those are physical risks, simply speaking. And of course, the transition risks are because of the changes in the policy that you have to undergo in order to meet the standards or the laws or the regulations that are framed to sort of address the issue of climate change, that is to say, reduction in the carbon footprint. The businesses are going to get affected, both because of what kind of finance it may be required, or the technology it may be required, or the resources which may or may not be available. Now, these are going to potentially cause tremendous amount of stress in the enterprises. And not only are they going to cause stress in the enterprises, they are also going to have more and more liability as people file claims against enterprises because of the damages or other kind of injuries that are caused to them because of the climate change. And the world has come to recognize that these damages are no longer to be treated as just environmental claims which are in the nature of torts. They need to be probably equated as, given as far more greater importance. Today, as we sit, those claims, whether filed by the government, for example, for cleaning waters where a ship spills the oil or any other kind of a thing, would invariably be treated as an operational debt and filed in IBC and fall far below in the waterfall. Now, if that is so the case, there would be no incentives for the enterprises to correct themselves, because they know that in the event of an insolvency, these debts would get wiped off, and therefore they don't have to really do anything to sort of make sure that these issues don't reoccur in future, or no loss or injuries caused to the human life and other kind of things. So therefore, the treatment of claims arising from climate change risks will have to be addressed in the IBC, in the Indian context, but globally in the insolvency law. Similarly, a very major call will have to be taken that how do you run the enterprise as a going concern if the enterprise is contributing adversely to the climate change, causing damage to the climate, then is or should the whole concept that liquidation is the last resort, corporate debt should be averted till the last, and we should try and run the enterprise as a going concern. That policy, which has been set by the Honorable Supreme Court in the judgments earlier, Swiss Ribbon, SR, will have to be reviewed. Although, of course, the law has always said that the lender should be able to liquidate the enterprise at any point in time. Now, these are just 2 examples that I've given. We have identified about 10 to 12 of those, but these need to be debated further. And I'm quite sure will have clarity on this in times to come, and this would really catch the center stage of the attention of the policymakers in a very short time to come. We don't have the luxury, and given that India has committed itself to be at the forefront of taking appropriate steps to address the issues of climate change, deal with the environmental issues without in any manner it's sort of standing in the way of India becoming a developed country by 2047, and also at the same time ensuring that India doesn't become a developed country at the cost of environment or damage to climate. So this is one point. The second point that I wanted to make was the issue of operational creditors. I know we all feel very perturbed by the judgments of the Supreme Court in Rainbow, in Prabjit Soni, and some of the other judgments where the operational creditors dues or the statutory creditor dues have come to be recognized. But in my view, this was a correction that was waiting to happen. This was something which is inevitable because the market has behaved very, very irresponsibly. financial creditors have absolutely been inward looking. They have not acted in their fiduciary duties the way they ought to have been. While, of course, we all understand that they sit higher up in the ladder. They put the water ball ahead of everybody else in the waterfall and fill up their pot. But at the same point in time, there was a clear expectation from them that they would take a duty of care and make sure that the interest of other stakeholders is also balanced, as in envisaged in the statement of objects of the IBC. And today, because of that reason, the statutory creditors feel completely shortchanged, that there is nothing left for them because the liquidation value is nil. As a result of that, today they are up in arms and they go to the courts, and even the government is beginning to feel sympathetic to their cause, that there is a tremendous amount of loss happening to the exchequer, while there needs to be a balance. So this is again another correction, part of it which has happened by the judiciary, and we may expect something that may also happen at the policy level as well. And also these dues of various landowning companies, how they have been treated, also has raised alarms, because I don't think that we have been as responsible in dealing with those. The third issue that I want to deal with is that the issue of delays, procedural delays. There are many reasons for that, but there are two primary reasons, if I may say. More at, if I may say, macro level, not at the micro level. Macro level, I do believe that the lack of the adequate number of members in the adjudicating authority have not allowed the members to be there to deal with a huge amount of cases that come up before them. And the reason for the huge amount of cases coming before the adjudicating authority are because IBC has become an adversarial litigation, which it was never intended to. And insolvency law around the world is meant to be non-adversarial. People are expected to address these issues by negotiation, by discussions, and not just rush to the court at the drop of the hat, which has become a culture over the last 7 years. IBC, the NCLT benches are flooded with the cases. Their benches are clogged with the cases, and those that could actually have been averted if parties would have acted responsibly and tried to negotiate this and reduce the workload of the adjudicating authority. And in order to address this issue, there are two things that are expected in the next 2, 3, 4 years. Besides, of course, I'm hoping that the number of members in the adjudicating authority, NCLT, would be increased substantially, keeping in mind 7 years. One is mediation. It is expected that mediation framework may find its place in the overall IBC. At the moment, Mediation Act doesn't allow exclusion of IBC, but there is a recommendation from IBBI and also by the roundtable that was held in Goa on mediation by international experts, which we hosted, where it was resolved and it was recommended to the government that mediation should be included as a part of the IBC framework and not outside for various reasons. Because of the shortage of time, I won't really go into those issues, but I have to say that mediation is something which is knocking at our doors and will probably address many problems, including the delays. The one other point which probably is also engaged the attention of the government is the pre-insolvency resolution mechanisms. Because since Lehman Brothers, and more particular after COVID-19, most of the jurisdictions around the world, the insolvency mechanisms, the resolution mechanism have shifted in terms of gravitating towards the hybrid forms of insolvency system, where you do most of the insolvency resolution outside the court, but in its shadow. And once you have a plan approved, you come to the court only to get it approved, so that it becomes so that it's tested on the parameters of law, that it is compliant of all the laws, and two, it of course, when approved, becomes binding on all the stakeholders. So you have best of both the worlds. You have the flexibility of a system which operates outside the court and doesn't constrains the players, who can then apply their commercial wisdom, use the way they want the process to ensure that it acts with speed At the same point in time, once they've agreed, they come to the court and request the court to sanction it. The combination of both the, if I may say, the RBI's July 2019 circular plus the IBC, the marrying the two together and producing a hybrid form of a new form of insolvency. That is also expected, although pre-pack was intended to be that, but it didn't really work out. So these are some of the things that I believe going forward are expected in the short term, in the midterm, and we hope that these will continue to strengthen the IBC, and IBC would champion itself as one of the most formidable economic reforms of the country, as it has in the past. Thank you so much for inviting me again, and thank you so much for your attention.
Thank you so much, Suman Batraji, for this keynote address to the insolvency professionals and lawyers present here. The most unique thing that was I read about you was you are targeting the climate change along with the insolvency processes that will be taking place. That's the best thing, or that's the innovative thing I found on your few pages. Thank you so much for the address, sir. Now I request the most awaited address from our chief guest, Honorable Shri Samir Kakkarji. Just a brief introduction. He is a fellow member of our Institute of Chartered Accountants of India and also the member of Triple IPI. He joined NCLT as member technical in October 2021. We all know him. We as a lawyers or the insolvency professional would have always pleaded, so he would have heard all of us. Now it's time to hear from you. A big round of applause for him.
Namaskar. Thank you, the organizers, Mr. Kabra, Mr. Purushottam, my co-speaker, Mr. Batra, Mr. Sunil, Mr. Sumit, the other council members, regional council members, the audience, which is most important for such an event. My previous speaker, Mr. Batra, has given a perspective for the IBC in future. He has also said that IBC has evolved over a period of 7 years, much more than what was expected, what has happened in other countries with similar laws. He's very right in that. As a member, I feel that so far as CI admission, CIRP, liquidation of a corporate debtor, more or less the jurisprudence has emerged in this country in a short period of 7 years' time. Maybe there are few areas where jurisprudence is yet to emerge, but then that continues, the jurisprudence continues to evolve. Enormous work has been done by the adjudicating authorities, the appellate authority, and also Honorable Supreme Court in the matters. We have precedents available in majority of the matters where disputes are there. So what's going to happen in future? As a member, I feel that personal insolvency, particularly so far as the corporate guarantors to the corporate debtor, jurisprudence is going to emerge. We have just started the climb. Presently, not much of the jurisprudence is available. 7 except the admission, that is 94 and 95 orders. Few cases orders under 100 have been given, and very few cases, order under section 114 is given. The difficult climb is going to be the bankruptcy orders. The number of RPs, the number of insolvency professionals who are holding valid AFA, in my view, is too less today. Capacity building is required in that area. We have perhaps around 2,400 persons holding valid AFA today. You can yourself compare when it comes to corporate debtor may have on an average 4 to 5 guarantors. Some of the corporate debtors have either been resolved, have been dissolved, or liquidation is going on. But for all those corporate guarantors, or corporate debtors guarantors, cases are now coming up before us. So you say any of the cause list of any of the NCLT today, majority of the matters are 94, 95, or order under section 100 or 99 reports. So that's one aspect. It's going to where we are moving towards in the next few years. Mr. Batra also said something about the members with the adjudicating authority. That issue is age-old. Since the NCLT has been established for the first time, we are having today the number of members which were not there hitherto. Largest number of members, Mr. Batra, we have today at NCLT. Unfortunately for us, we have a very dynamic and understanding president, Honorable Justice Ramlingan Sudhakar, who is trying to assist us in all the ways and motivating us at all the times. So that's one aspect. Yes, the selection process is presently on. We may have few more members. Times to come, months to come. We have taken some very good steps in the recent past. We have recently started hybrid hearing at all the NCLTs. That's one reform we have already implemented. And we are going to have Wi-Fi connectivity at all the NCLTs very, very shortly. So as to the disposal of cases, I must say at one point or before that, yes, this law kicked in at a time when the stress in the banking system was too much. We had the highest number of NPAs in the system at that point of time compared to the loans given to the corporates. So there was a backlog which was built in the system. First task was to deal with that particular backlog. Fortunately for us, last 2-3 years, the economy is on an uptick. So what is today? Today we are dealing with the backlog. Majority of the backlog we have cleared. Fresh cases which are trickling in small numbers today at each of the NCLTs. We have been sensitized, all the benches have been sensitized that high value cases. Now what is high value case? A case involving a debt of more than 100 crore. We are already fast tracking those cases. Not many adjournments are given in all that. And this applies to whether it is a corporate or whether it is a personal guarantor. We are already fast-tracking that, monitoring it very closely. We are expected to give orders soon, not to keep it reserved for longer time. And there is a continuous monitoring of all these cases, let me assure to you, all of you here. Few very small discussion I had with the office bearers here. I asked them what I'm expected to speak about, or your queries or your anxieties. Let me address that, because you have very few occasions when you interact on the other side. Usually, yes, from the bench we address all of you. Many of you here, they come before us. So I was asked to speak about speedier disposal on resolution plans. Second topic was guidance to the professionals, especially the young professionals, on the opportunities available at NCLT. So let me address the first issue, which probably will cover for certain more areas what we expect also from the bar. What we expect is that when cases come before us, you should be very clear what you are going to say, what you are seeking. When you yourself are not clear, what are you going to ask? Case becomes complicated. Second, if you are clear what you are going to ask, the way you will present will be good. But if you are confused, you have given a Form H, which is half of it is blank. How do we make it? Few of the cases we have had that in which the Form H was completely blank. Form H proposes some distribution which is other than what is there in the plan, what is minutized. There is no clear-cut resolution of this COC. No voting is placed before us. So far as compliances, majority of the RPs who come before us, it's a very hard-hitting thing to tell you, but they don't read it. Either like a bus or a train which is moving out of the platform, in a rush, whatever is placed, they sign, and it is filed by the lawyer. My piece of advice, sit back, relax for half an hour, at least read what you are going to file. Please do that. Humble request to all of you. You will yourself come to know the shortcomings. At that stage, if you correct, it saves time for everybody. Many of you attend NCLT hearings, and that's what we have been telling to each one of you, that, okay, please go through the file before you submit at NCLT. Legal issues, other issues, we can debate, all that can happen, but the facts have to be very clear placed before us. So as to speedier approval of the resolution plan, I think 2023-24, we have touched nearly a figure of 270 all over India wise. And let me assure you at this stage that 2024-25, we have been sensitized and we are moving towards a regime which you will see that majority of the resolution plans, much in excess of 270, will be approved in the current year. On the topic for advice to the young professionals, particularly chartered accountants and other practitioners. IBC and Companies Act provide ample opportunity, numerous opportunities to young professionals. Right from filing of an application to submitting of a claim, to advisory to your various clients, representation before the NCLT, drafting of resolution plans, assisting the seniors on the resolution plan. During the liquidation process, everything is available to you. Let me at this point of time narrate one incident. Many times I have been asked a question that as a practicing CA, as a practicing advisor, why did you choose this field? Because CAs have a lot of numerous opportunities available to them in the field of audit, taxation, attestation, so many other aspects, which you know better than me. So I came here and in the field of stressed assets in the year 2000, when the economy was on a downtrend. So the question being put to me was, why you have chosen a dot? Because stressed asset advisory in the total field of advisory for a CA is just a dot. Many of the seniors here may agree with me on this aspect. But friends, don't worry. Sometimes a dot can be as big as a world. The dot today, to me, is my world, which has ample opportunities for everybody. Keep your briefs with you. Read your applications. We are not here to discourage a young professional, we'll encourage rather. Many a times sitting on the bench, we have said so that, okay, today is your day, if the senior is not available, come on, make your representation. Don't hesitate. A junior only becomes a senior. I think I've almost reached my time limit. Thank you very much.
Thank you so much, sir, for your lovely address and also the suggestions to the insolvency professional and to the young practitioners as well as to how to appear in the NCLT before the honorable judges. Thank you so much, sir, for accepting our invite. A big round of applause again for our chief guest, Honorable Shri Sameer Kakkarji. Also thankful to Durgesh Kabraji, the Vice Chairperson of Insolvency and Bankruptcy Board, the Central Council member, Sumant Batraji, for coming all the way from Delhi for his keynote address, Purushottam Khandelwalji, our own Central Council member, and our team, the entire team of Managing Committee member, Sunil Sanghvi led Chairman of Ahmedabad branch, all the Managing Committee members here and all the present here. I wish you all the great learning the entire day. Thank you so much.